Artie, thank you so much for being here and welcome to New Mexico in Focus.
Thank you very much for having me. Glad to be here.
I remember hearing the title Administrative Office of the Courts when I was a brand new journalist a couple of 20 years ago or so. And even for a reporter who was super interested in the justice system, that name of that office made me feel a little dead inside and kind of numb. So let's start here, Artie. What is the office that you have run for the last 18 years and what does it do?
The Administrative Office of the Courts is the administrative arm of the Supreme Court. The Supreme Court's charged with running the whole judiciary, 2,000 or so judges and employees. It's kind of like, the governor has, whatever she's got, 25 cabinet agencies. We're the cabinet agency for the state Supreme Court. So there's lots of things that go on besides judges judging cases. They need buildings to do them in. They need personnel to support them, all kinds of things. So budget, HR, all those things. That's what the Administrative Office oversees. Obviously, things like human resources are administered locally in the courts. The AOC sets the rules. The AOC assists them, provides training, train all the judges and all the staff, all those kinds of things that you would think an agency would do. We are the agency for the Supreme Court.
Gotcha. You just mentioned the acronym, and I'm not sure what it says about me, that when someone says AOC, I do not immediately think of a certain congresswoman from New York. But let's talk about your job, the job you've had for almost 20 years. What does the director do at AOC?
So the director of the Administrative Office of the Courts, the AOC, oversees all of that. Your first responsibility is to listen and be guided by the directions of the Supreme Court. Most specifically, the Chief Justice. You interact a lot with the Chief Justice about all those things that are going to affect the courts throughout the state on a daily basis and then more long-term policy basis, budgets that we're trying to submit to the legislature, all those kinds of things. So on any given day, the AOC director may be involved in a serious personnel matter, maybe talking with legislators about a piece of legislation that we support, talking with PERA about a proposal we might want to do to try to shore up the solvency of the Judicial Retirement Fund, anything. Or dealing with an issue that's come to the public's attention that's controversial, that needs to be addressed by the courts to the degree we can address it. Of course, most of the time, case in front of a judge isn't allowed to talk about it by ethical rules. Well, that falls to someone like the AOC director to say, here's what we can say, here's what will happen going forward, here's as much information as I can provide to the public because you have a right to know. Most of what I can tell you, some things are confidential until they're not, and we make that clear too. So anything that has to do with something other than what the judge does in court, process a case, decide who gets custody of a child or if someone is guilty of a crime. Those are things judges do. We do everything that supports the ability to do those things.
Gotcha. I want to get to a couple of those issues of public import or controversy, as you said. Let's start with bail reform. And I want to take that particular issue sort of chronologically. Let's go back to, say, 2015. What was the state of the pretrial release system in New Mexico in that year?
As in almost everywhere in the country, perhaps everywhere in 2015, when you got arrested for a crime, there was a bail schedule. The bail schedule said if you get arrested for this crime, you're charged with robbing the 7-Eleven, armed robbery of a 7-Eleven. That might be a $10,000 bail bond. If you can come up with the $10,000, you get released. Every crime, and that's a serious one, but every crime, from the top to the bottom, whatever you think is most serious to least serious, would have a number attached to it, a dollar figure, and if you came up with the money, that's fine. If the $1,000 was the bail, you could go to a bail bondsman, and if you paid them $100, they would post the $1,000 and you'd get out. If you didn't show up to court, you owed the bail bondsman the $1,000 because they would have to pay the court the $1,000 sometimes. I won't go into the details of the law. But that's the way you got released when you got arrested for a crime. You posted a bond and you got released. And that was true everywhere. It still is true in the majority of states in this country. If you get arrested for a crime and you have $500 in your pocket, you probably walk out the door. If you don't happen to have $500, you'll stay in there no matter what. They could have arrested the wrong person. You could be guilty as anything. None of those things matter much to whether you get released or not. What matters is how much money do you have in your pocket.
The late Chief Justice of the State Supreme Court, Charles Daniels, used to call it the money for freedom system. Artie, briefly, what were some of the consequences to people who got incarcerated of that system?
So the best data we have is on a focus on Bernalillo County. We had the best data in Bernalillo County, but it's true all over the state. In Bernalillo County, 60% of the people in your detention center were there because they hadn't posted a bail bond. And most of those bonds were under $1,000. So you needed $1,000 or less to get out, but you didn't have $100 or $400 or $500. And you would stay in jail until your case got resolved. So if it took the judicial system 6 months to resolve your case, 6 months you spent in jail. A year could be significantly longer. I think we're going to talk later about some reforms we did about that. But whether you stayed in jail or not didn't have anything to do with whether you're a dangerous person, you're likely to be a threat to the community or to a victim. It had to do with whether you had the money to get out. And that's unjust and it's unconstitutional. And that's why Justice Daniels got to work to reform the system. And he was spectacularly successful, in my opinion.
A little thing called the innocence presumption, but that would be a whole other 20 minutes we could talk. Let's talk about the reforms that came down in 2016. What changes were made and what was your role in changing them?
So Chief Justice Daniels wrote an opinion about the bail system, the money system, and pointed out that it had always been unconstitutional, but we had gotten into the same practice as every other place in the country doing money. So he convinced Senator Peter Wirth, the majority leader in the Senate, to sponsor a constitutional amendment to make it clear, two things clear. One, that judges would have the authority to keep someone in jail pre-trial before they're convicted, when they're presumed innocent, if they were too dangerous to be released. Colloquially, there's specific language in the Constitution, but that's what it means. And otherwise, in the great majority of cases, people should be released, and their release shouldn't depend on whether they had money or not, whether they were rich or poor. It should depend on whether or not they posed a significant threat to public safety. And in between that, if you're not going to hold someone in jail because they're one of those too dangerous people, then what conditions do we want to set on those people in order to maximize the likelihood that they're going to return to court and they're not going to get arrested for a new crime before they get this case resolved?
This has obviously continued to be a hot button issue. There are lots of prosecutors and cops and keyboard warriors out there who blame bail reform for, very, very sort of difficult to solve high crime rates in this state. What do the data show in terms of the way the pretrial release system works now and how it relates to crime?
The data, we've studied the data very carefully because we believe we should make data-based decisions and set policy based on what evidence shows works. Get rid of those things evidence shows don't work. And the evidence shows that most people released under conditions return to court and don't get arrested for a new crime. Even those charged with very serious crimes. In fact, the people charged with the most concerning kinds of crimes that get released, some of them get detained, but of the ones that get released, they actually have a better appearance rate and a lower arrest rate than the average people who get released. There are reasons for that, but that's not just, we don't just say that. We don't just come out and say, oh, well, look, we looked at it and it's working fine. We take all the data, in this case, 20,000 cases or so since 2017 in Albuquerque. We give them to researchers at the University of New Mexico, the Institute for Social Research, and we say, we would like you to look at all this data and tell us how many people get arrested while they're on release, how many people fail to appear in court, and then working down into the more granular level of those who get arrested, what do they get arrested for? Is it something that frightens us? Are we releasing people who get arrested for serious violent offenses? Or are those who get arrested getting arrested for fourth-degree felony or misdemeanors or petty misdemeanors, things that are crimes, and they should have a consequence, of course, but aren't the kind of things that we say, oh man, that was really a mistake to let that person out. And the data shows that very, very few of those people that get released get arrested for the kind of serious violent crime that concerns us. As for the crime rate, that depends on police data and FBI reporting, and the crime rate went up significantly during the pandemic. It's come down significantly since the pandemic ended in the last year and a half or so. And there's never been any data to show that pretrial release has a lot to do with the crime rate. And I understand people are worried about turnstile justice. The Supreme Court made some significant changes this year to try to address those legitimate concerns about people get released who maybe, who get arrested for a new crime, we should be concerned about. I could talk about those, but the court has made 3 different kinds of changes since the implementation in 2017 to address concerns about the kinds of issues you ask about.
That data is going to be inconvenient for a lot of people to hear and has been. I want to spend just a moment on one other change that kind of came down during your time at AOC. It's a thing that nerds like me will remember as LR 2400, commonly known as the case management order. Briefly, what was that and what was the problem it was aimed at fixing?
So the case management order, I'll call it CMO because that's what we've been calling it for many years, was a product of a serious problem in Albuquerque with jail overcrowding. You had 3,000 or more people sent to the Metropolitan Detention Center, MDC. Well, the jail capacity is about 1,800 or 2,200 if you include the hospital wing. You can't put, anyway, say it's 1,800. 3,000 is too many. The county was sending people to Texas to keep them in jail, to other counties to keep them in jail, remembering 60% of them were pretrial detainees who couldn't pay a bond. And it was costing the county over $1 million a month just to try to house the people that were sent to the jail. And that clearly that shouldn't be. The Supreme Court, the legislature created something called the Criminal Justice Commission in Albuquerque, and for reasons that mystify me, they put me in charge of it. And one of the things we realized in the commission was we have to do something about why the jail population is so big. They had a jail, they built a brand new one, and it's way over capacity. That doesn't make a lot of sense.
Overcrowded the day it opened.
Exactly, and more overcrowded as we went along. So along about 2015 or so, we began trying to figure out why that was. And engaged in a lot of it was a responsibility of the court. To try to be as simple as possible, a criminal case comes in, it gets assigned to a judge, and that judge is going to be with that case until that case goes to trial or they plead guilty, it gets resolved. Well, somewhere along the line in that case, somebody brings a motion to suppress evidence. Judge schedules it on his next available date or her next available date, 2 months out. That day comes, the prosecutor's busy in another trial that got rescheduled or something, can't have that hearing. Okay, when's my next available date? Judge says, all right, 2 more months, 3 more months, whatever. We'll do it 3 months from now. And this goes on and on until you've got 4,000 cases that have been pending for over 2 years, many well over 2 years, of which many of those people were sitting in jail that whole time. So we recommended to the Supreme Court that they impose a special local rule, the CMO, that did a lot of things, but one of the main things it did was it required the court to determine at the beginning what the trial date would be. They limited the trial date 9 months, 12 months, 15 months out. Nobody more than 15 months out, the majority 9 months out. And work backwards from there. We're going to have a hearing on the evidence on this day. We're going to have our last hearing before trial on this date. Last plea hearing deadline is going to be 2 weeks before trial, so we're not going to come in on the day a jury is sitting in the box and we decide to resolve the case. And if that judge isn't available, who's assigned to that case, we've got a judge somewhere in this courthouse who's available to conduct that hearing for the next hour or two. They're going to do that hearing because, after all, the judges in this county and throughout the state are quite capable of opening a file, listening to the lawyers argue, listening to the witnesses, and making a decision. It's what they do every day. Just because they haven't seen the case before doesn't mean they can't do it. And that way, that 9-month trial date, 12-month trial date will happen. That made all the difference in the world in whether or not your case is going to be 2, 3, 4 years old before it got resolved. So in the space of 2 years, that schedule was firmly fixed and everybody did things that way. Now, what did we do with all those old cases? The court took 4 judges, assigned them to a special calendar and said, resolve these 4,000 cases and do it as quickly as you can. I thought it would take 2 or 3 years. It took them about 18 months. A lot of those cases were so old, those people shouldn't have been in jail because they really didn't have a case. The prosecutor would dismiss the case saying, we don't have the evidence, or the policeman went to work in Alabama, we're not going to go forward with this case. And some of them went to trial. They were in trial every day, all week long for years. But it took about 18 months, and we caught up, and it's been that way ever since.
You unglued the system.
That's the idea.
Artie, we have a few minutes left here, and I want to ask some sort of bigger picture questions. What are some of the successes during your time in that office that we haven't talked about so far today?
The biggest one probably is language access. When I came in, we had a language access group, and we tried to provide interpreter services in the courts, but too often that might mean a family member who spoke Spanish and English would be the interpreter. We worked very hard to get certified interpreters. The certification test is a national exam, very hard to pass, but we wanted neutral certified interpreters. We wanted them available in court and in court-related proceedings so people understood what was going on in their case. And over the course of 18 years, we become really a national leader in the provision of interpreter services.
Why was that so important in a state like New Mexico?
Well, something like 40% of our citizens speak a language other than English, generally Spanish, at home. There are over 60 different languages that get used in courts every year. Some of those, obviously, we have to reach out to other states to find interpreters who are available. But you have to, if you're going to provide access to justice, the person has to understand what's happening to them. And not just in criminal cases. Criminal was the first we did, but also in civil cases. If your neighbor sues you because you put the fence 5 feet over the line, when you get that piece of paper in English and you don't know what it means, maybe you have some lawyer friends or you've got enough money to hire a lawyer, but maybe you don't. You should be able to get that in a language you understand so that you can respond appropriately, resolve the case with your neighbor, whatever it is you're going to do. Children, people are going to lose their children. They should understand what the risks are and what the rules are and, how cases work. Interestingly enough, Chief Justice Chavez wrote an opinion back early in my tenure with the AOC that recognized we have a constitutional provision that says you have to be allowed to serve on a jury even if you don't speak English. It's the only state in the country that has that in their constitution, and we had ignored it for 90 years or so. People routinely were not allowed to serve on a jury if they didn't speak English. Our solution was, well, we're going to make rules that allow an interpreter to assist that person during jury service. And many of my colleagues to this day say, I don't even know how you could possibly do that. It's not that hard, actually. The court wrote smart rules, and it works just fine. That was another driver, though. We have enough. If you're going to do it in any state, well, you probably pick California because they have the most people who don't speak English. But as a percentage of our population, we have the most. And after all, it's the right thing to do, and that's why we do it.
Artie, my last question is a two-parter. What do you see as next for the court system in New Mexico, and what's next for you?
For the court system, it's not up to me anymore, but I hope the court is successful in a significant initiative in this legislative session to get our employees paid better. Our judges are paid well now, thanks to the legislature and the governor signing the legislation. That's great. Our employees are paid roughly 10 to 12% less than comparable employees on the executive side, let alone is that a living wage to begin with. Data tells us, no, it's not. We have lots of employees who would qualify for a public defender or for aid to families with dependent children. I don't think they call it that anymore. Or SNAP, all those federal programs that are poverty-based. Yeah. You have 150% of the federal poverty level. That shouldn't be. You should make a living wage if you're working for the courts. Our employees are great. They're dedicated. Generally, they really love their work, which is great, but they should get paid better. So I hope that succeeds. I think we're finally getting close to being able to broaden public access to court data. You can always get what you want if you go down to the courthouse, but that's not the age we live in. We'd love to make it the data more available electronically.
Yes, please, as a reporter.
Well, yeah, we've broadened it, but that door needs to be opened further, and I think we'll work very hard on doing that. And other than that, there's always new issues and new problems that come up. That's one of the great things about the job the Supreme Court gave me, which I was privileged to have for a long time and enjoyed very much doing something new, always on the horizon that you really want to dig your teeth into.
Artie Pepin, outgoing director of the State Administrative Office of the Courts, thank you for your time today and enjoy your retirement.
Thank you very much.